Okay, so good morning everyone and welcome to this morning's webinar on sexual harassment. I just let somebody else in. Please kindly note that this morning's webinar is being recorded. So, over a year ago now, employers were made subject to a new legal duty requiring their organisation to take reasonable steps to prevent sexual harassment before it happens, rather than a mere responsive approach. Today's webinar is going to provide a quick recap of the law on sexual harassment. It's going to take a look at the impact of the new duty over the last year, and also look ahead to the new duty under the Employment Rights Act to take not just reasonable steps, but all reasonable steps. My name is Rebecca Ware and I am a Employment and Education Solicitor with First North Law, and I am accompanied this morning by Senior Employment and Education Solicitor Mark Hards.
Good morning.
Today's webinar is being delivered in partnership with YPO's Legal Services Framework. First North Law is one of several providers that you can see on the screen across a number of different lots, covering a full range of legal services for the entire public sector. So, over the next hour, we will look at a refresher of the legislation on sexual harassment in the UK, specifically recapping the position within the Equality Act 2010, the duty introduced in October 2024 under the Worker Protection Act 2023, and the new duty coming in under the Employment Rights Act 2025. We'll be looking at how you can prepare for change within your organisations, considering in particular what risks may arise for you as an employer in your organisation, potential high risk factors that you need to consider, updating your policies, training and auditing your workplace culture. There will also hopefully be some time at the end of the webinar for any questions. I'm sure that you will have seen within the media over the past couple of years that taking action to recognise and actively prevent sexual harassment has been the subject of a number of high-profile campaigns. And connected to this, alongside the changes to legislation, we have seen a number of surveys carried out to measure the scale of the issue and the impact of the changes that have come in. I'm just going to run through a few survey results to put in context the scale of the matter. So starting firstly with the statistic that you can see on the screen there from the Office for National Statistics, which found that in the year ending March 2024, 21.8% of people aged 16 years and over who have said that they have experienced in-person sexual harassment in the last 12 months said that they had done so at their place of work. Following on from the introduction of the new duty to take reasonable steps to prevent sexual harassment, between January and June 2025, the Advisory, Conciliation and Arbitration Service, otherwise known as ACAS, received almost 5,600 calls about workplace harassment, and that represented a 39% increase on the same period the year before. In July 2025, Unite found that 25% of the 6,615 women which they surveyed had been sexually assaulted at work. Of those, 56% had been the recipient of sexually offensive jokes, 55% had experienced unwanted flirting, gesturing, or sexual remarks, 43% had been inappropriately touched, and 28% had been shown pornographic images. Almost half of those sexually harassed at work had been harassed more than twice, with a third experiencing sexual harassment more than once. Also in July 2025, Unite found that 75% of the women who had experienced sexual harassment at work did not report incidents. So that's a real high percentage. Reasons given for not reporting incidents included that they felt that they would not be believed by their employers, or that they felt that their jobs would be at risk if they raised the allegations of sexual harassment. And Unite found that those concerns were reinforced by those who did report, because they were saying that when they did report sexual harassment, they found that they were disbelieved, they were accused of lying, and in some instances, they lost their jobs. Interestingly, alongside those that were saying that they had lost their jobs because of raising an allegation of sexual harassment, they were also reporting that the perpetrators who they had made complaints about were allowed to remain in the workplace. And in some cases, there was even reports of those individuals being promoted. So, having put everything in context, let's now remind ourselves what the law on sexual harassment is in the UK. Of course, the starting point, which I'm hoping you are all familiar with, is the Equality Act 2010. Section 26 of the Equality Act, which is referenced on the slide in front of you, prohibits 3 types of harassment. And they are harassment related to a protected characteristic, sexual harassment, and less favourable treatment because the employee rejects or submits to unwanted conduct of a sexual nature, or that is related to gender reassignment or sex. Under Section 26(2) of the Equality Act, we find the definition of sexual harassment, which is unwanted conduct of a sexual nature, which has the purpose or effect of violating an individual's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive working environment for that person. So we know what the Equality Act says. Let's remind ourselves of the changes that came in under the Worker Protection Act 2023, and I'm going to hand over to my colleague Mark to take you through those.
Okay, thank you, Rebecca. So, the 26th of October 2024, we had introduced the Worker Protection Amendment of Equality Act 2010, Act 2023. And what this does is it introduces 2 new sections into the Equality Act 2010. Those are sections 40A and section 124A, which are now part of that act. Those sections basically introduce a new proactive duty on an employer to take reasonable steps to prevent the sexual harassment of employees in the course of their employment. So the employer must take reasonable steps to prevent sexual harassment of employees in the course of their employment. So what does that mean? Well, an employer must take action in order to assess risks and put appropriate measures in place. In essence, you can't just sit on your hands as an employer and wait for sexual harassment to happen. That said, if it has already happened, then the employer should take steps to make sure it doesn't happen again. The law covers harassment both from other people at work, from fellow workers, colleagues, managers, etc. But it also covers harassment from third parties, customers, clients, other parties as well. So those duties already exist. So it is important as an employer that you do consider what reasonable steps you may be able to take to minimize or eliminate sexual harassment in the workplace. Now, that is important because if you don't take any reasonable steps to prevent sexual harassment, it is possible that the Equality and Human Rights Commission could actually take action against you for failing in that duty. Not only could that occur, but should an employee bring a claim to an employment tribunal and that proves successful against you, then it is quite possible that the tribunal will decide to award a higher rate of compensation as a result of your failure to take any reasonable steps to eliminate sexual harassment. So it's important to give it due regard. It's important to consider what risks exist and what could you do potentially to minimize and mitigate those risks. Okay, if we can move on to the next slide, please. So the Act also provides a broader definition of sexual harassment to encompass unwanted conduct of a sexual nature, including but not limited to unwanted physical contact, verbal harassment and jokes, visual harassment, e.g. staring, displaying offensive materials, and creating a hostile working environment through those behaviours. So again, important to remember what sexual harassment covers. It isn't just physical contact. It can be comments, jokes. It can even just be staring, even displaying offensive materials, not directly towards the victim of sexual harassment. It might just be in the presence of, but they are aware that you are doing it. So again, do remember what the definition entails when, again, thinking about what risks exist in your workplace and what could you do to potentially minimize those risks. Okay. Continuing with the Act also specifies that employees have the right to report harassment without fear of detriment. Employers must provide clear reporting channels and protect employees from victimization. So Rebecca had already commented how some people feel that they are disbelieved, that they're at risk of losing their job. Realistically, what this Act is saying is that all employees should be able to approach management, approach their employer to report harassment, and they should suffer no detriment whatsoever for doing that. So even in a case, if you had somebody report sexual harassment, if it was investigated and disproven, certainly unless it's vexatious or malicious, then there should be no detriment whatsoever to the employee for choosing to speak up. The Act is basically giving them a safe environment to be able to raise these concerns without fear of any detriment or repercussion. So I've already referred to the Equality and Human Rights Commission. They're very useful. I would recommend, if you look for further materials on sexual harassment, to visit their website. There's a lot of guidance, including technical guidance that I'll be making reference to over the next couple of slides. So in late September 2024, the Equality and Human Rights Commission published an update of its technical guidance on sexual harassment and harassment at work. Now, that technical guidance is directly aimed at employers, employees, and their representatives. It will explain, amongst other things, the employer's legal responsibility to deal with harassment and victimization in the workplace. It will also include the positive legal obligations relating to the new preventative duty. And it will provide practical guidance on how employers can fulfill their preventative duty. So like I say, I'd strongly recommend you find time to look at this if you've not done so already, read the technical guidance, see how it can help and support you. So the guidance offers also useful examples of potential sexual harassment, and I wanted to share one of these with you. So within the technical guidance, it gives an example of a male worker altering a pornographic image by pasting an image of a female colleague's face onto it. He then sends it around to other colleagues, causing them to ridicule her. There was actually no sexual motivation in that act, but the use of the image is sexual in nature. So that was contained in paragraph 119 of the technical guidance document, it is an illustration of where sexual harassment can occur. So for all, it wasn't sexually motivated, it was a joke, banter, call it what you will, but it would still certainly be harassment. That person was ridiculed as a result of that act. It is harassment. It would breach law. And I'll give also a real case example. So this is a case of Moonsar against Five Ways Express Transport Limited. It was heard in the Employment Appeal Tribunal. And what this case did is it made it clear that conduct doesn't have to be directed at a claimant. I've said before, if it's in the presence of, you might be at risk of sexual harassment. So in this particular case, Mrs. Moonsar was a data entry clerk who worked evening shifts. On 3 occasions, she was aware of male colleagues downloading pornographic images onto computer screens. Now, the claimant wasn't shown the images, as she had not made any complaint actually at the material time. The Employment Tribunal, which it went to, initially found no discrimination. Sex discrimination, that is, of course. However, the Employment Appeal Tribunal, having been appealed to them, they substituted that finding to one of discrimination, holding that this was treatment that would obviously undermine the claimant's dignity. So, again, even if it's not directly shown towards somebody, inappropriate action, use of looking at inappropriate materials within a workplace and in the presence of others can risk sexual harassment and sex discrimination taking place. Okay, if we could move on to the next slide, please. So the technical guidance also gives examples of unwanted conduct of a sexual nature. The list isn't complete. Don't view this as exhaustive. They are just examples. So what the guidance suggests is it covers a wide range of behaviour, such as unwanted conduct of a sexual nature, which is sexual comments or jokes, displaying sexually graphic pictures, posters or photos, making suggestive looks, staring or leering, making propositions and sexual advances, making promises in return for sexual favours, sexual gestures, sexual posts or contact on social media, or spreading sexual rumours about a person. Now, again, I want to emphasise that list isn't exhaustive. There are illustrations of where sexual harassment can take place, but don't ever feel that those are the only instances. There may well be others. Now, I just want to give a couple more case examples here at this point, just to help illustrate some of those points above. So the first one is a case of in situ cleaning company against Heads. It was a 1995 case. And what this established and helped to establish is there was no need for one employee to make it clear that the other employee's conduct was unwanted in order for it to constitute harassment. In the case before the tribunals, the employer tried to argue that a man wouldn't know whether his conduct was unwanted until it had been rejected or failed. The Employment Appeal Tribunal said that would-be harassers cannot be allowed to, as they put it, test the water with impunity to see whether their conduct was objectionable to potential victims if their conduct is serious enough to reasonably be considered to be harassment. So again, it was just establishing the point that you don't have to undertake any kind of testing. You don't have to think, I've said these things or I've done these things and it's been rejected, and now I'll correct. You've already committed sexual harassment if that behaviour is inappropriate. So just to offer another case example where this clearly could be inappropriate behaviour, a case of Smith against Renrod Limited. Miss Smith was employed as a sales executive in a car dealership, and she made a claim that she'd been sexually harassed by her manager. Now, she alleged that his behaviour included telling her that he hadn't heard what she was saying because he was too busy. I'm not going to give you the exact phrase because I need to censor myself, but I will say that he hadn't heard what she'd been saying because he'd been too busy having sexual thoughts and actions about her. He'd also attempted to kiss her. He'd pestered her about her private life, and he made speculative comments about her sex life and relationship with her boyfriend. Now, initially, the tribunal actually found there was a culture of sexual banter and sexual behaviour in the workplace in which both Miss Smith and her manager actively participated. It concluded that Miss Smith wasn't actually shocked by the day-to-day banter between colleagues, which didn't go too far. However, the tribunal then found that the comments made by her manager did go too far, did go beyond banter, and became the type of personal innuendo and questioning which was offensive and unwanted conduct. So while the tribunal found that Miss Smith was actually quite robust and wasn't adverse to participating or even initiating sexual banter, the conduct and the comments of the manager went beyond what was acceptable to her. The tribunal also took into account that it may be harder for Miss Smith to deal with and complain about the behaviour of her manager. It noted where a culture of sexual banter exists in a male-dominated industry and is actively condoned by a male manager, a female employee may almost feel compelled to join in with and not take offence at language or conduct that they would otherwise find demeaning. And this will always be a problem with sexual harassment. There will be that claim of it's banter, and it's difficult to draw the line. There may be some areas where it's recognised by a tribunal that a degree of relatively innocent banter may exist, which people might be robust enough to listen to and not feel personally offended by. But equally, I would always suggest as an employer, I'd almost take a zero tolerance approach would be my advice, and not, we can accept certain degrees of innuendo, sexual remarks as some just kind of general workplace banter that everyone will agree to. I think you're always running risk if you should do that. But to give an example of a claim where actually sexual harassment wasn't found, I'll just run through briefly the facts of Nunn against G&MJ Crouch and Son Limited. This was a recent case in 2025 before the Employment Appeal Tribunal. So Miss Nunn was employed by G&MJ Crouch. She'd been employed by them for 7 years. She resigned, brought a claim in which she alleged several incidents of harassment, including incidents where she'd be referred to by terms including eye candy, office cougar, MILF, and a belter. The tribunal accepted that those incidents had occurred. However, the tribunal also noted that Miss Nunn had valued and encouraged closeness between herself and her manager and had blurred the nature of their working relationship. She'd willingly engaged in conversations of a personal nature with him, believing this made their relationship closer, and it was important to her to be considered more than an ordinary employee. Consequently, the tribunal felt that the conduct could not be described as unwanted. That decision was upheld by the Employment Appeal Tribunal, that found that the tribunal had been entitled to reach the conclusions that it did on the facts and that could not be challenged on appeal. It also noted that Miss Nunn was actually quite forthright in her opinions with her manager, and that suggested she was capable of complaining if she'd been upset at an earlier time rather than after the end of her employment. So there's an example where sometimes because of the robustness of the individual, certain comments may not necessarily be found to be sexual harassment. Okay, if I could move on to the next slide, please. So, unwanted conduct. So the EHRC considers that the effects of a single act of harassment must be longer in duration to create an offensive environment. But a single incident which does not have an enduring effect could still violate a person's dignity in the moment. And that again is within the technical guidance, it's at paragraph 1.32. It also makes the point that sexual conduct that has been welcomed in the past can become unwanted. That's paragraph 1.22 of the technical guidance. Now, again, I've got hopefully a couple of case examples which might help illustrate this. So the first one was a case of Reed against Stedman. It's a 1999 case, and this just actually emphasised the first point that the EHRC had made. That case established that a single incident can be enough to constitute harassment. It did recognise that the effects may need to be longer in duration to create an offensive environment, but that it could still arise. So just be wary. Obviously it doesn't need to be multiple acts. It doesn't need to be repeated for it to become harassment. We know, say, the Protection from Harassment Act will talk about 2 or more incidents before action could be taken. As far as potentially a claim to an employment tribunal could be concerned, it could just be 1 incident, and that might be enough. Another case, the case of Chen against Kutyo Wolf Loose Limited and others. An employment tribunal in this case found that an air kiss wasn't unwanted conduct of a sexual nature. The tribunal found it wasn't at a level taking into account the individual's perception that it was reasonable for the individual to have the prescribed effect of sexual harassment on her. It should be worth noting that the tribunal in this case also found that the individual who complained had an openly friendly relationship with the person whom she complained about. And it was circumstances where she hadn't really set out very clearly evidence that was given against her. So it's just another example of where it might be close, but what may or may not be sexual harassment. The tribunal in this particular case felt that an air kiss wasn't going to be enough to actually reasonably offend an individual and be harassment in nature. So just sticking with some principles from this and from the guidance. So if an individual's unwanted conduct of a sexual nature is shown to have the purpose of violating the victim's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment for them, then the definition of harassment is made out. Now, if that's the case, there's actually no need really to consider the individual's perception of it. But if it's not clearly shown that the conduct has had that purpose of creating the humiliating and offensive environment, then the effect on the individual should be considered. And when you consider whether it has violated a person's dignity or created a hostile and offensive environment, there were 3 factors that were felt needed to be taken into account. Firstly, the individual, the victim's perception. Now, that's a subjective test, so it's how the individual feels, not how a reasonable person would feel, how the individual feels. So I would say that more often than not, if an individual has complained about the behaviour, then their perception is it was harassment. The subjective test is likely to be passed. You'd also need to consider the overall environment and circumstances of the case, and then whether it's reasonable for the conduct to have that effect. So that brings in a degree of an objective element. Is it reasonable for the individual to feel that they've been degraded? Now, just one more case I'm going to mention for you, a case of Pemberton against Inwood. This was 2018 case, and it's a quote from Lord Justice Underhill. What he held was, in order to decide whether conduct has either of the prescribed effects, the tribunal must consider both, firstly, whether the claimant perceives themselves to have suffered the effect in question, so that's a subjective question, and whether it's reasonable for the conduct to be regarded as having the effect, the objective question. So again, the relevance of the subjective question is if the claimant doesn't believe their dignity is being violated, then conduct shouldn't really be found to be of sexual harassment. The objective question, if it's not reasonable for the conduct to be regarded as violating dignity or creating an adverse environment for them, it shouldn't be found to have done so. So you've got that. So there's both subjective and objective elements to whether subjective sexual harassment occurs. So it's just a test to be borne in mind. But again, I'm going to go back to a point I said earlier with regard to banter, as many people put things. Personally, I would take a risk-averse approach as employer. I wouldn't allow for banter of a sexual nature, jokes which might potentially create a humiliating and offensive environment to take place. I think if you know of them, tolerate it and just think it's workflow, banter and gossip, you are taking a risk as employer. Okay, if we can move on to the next slide, please. So we've obviously just had recently passed the Employment Rights Act 2025. This will have new provision about sexual harassment. And what it intends to do is introduce even tougher obligations for an employer to prevent and respond to sexual harassment in the workplace. So, as we've already mentioned, the existing legislation says that employers must take reasonable steps to prevent sexual harassment at work. The new duty that's going to be introduced by the Employment Rights Act is that an employer will take all reasonable steps. Now, that is a significant shift, in my opinion, that will create greater accountability for employers. They'll need to demonstrate that they're taking meaningful and proactive steps to create a culture and a working environment which seeks to prevent and is free of sexual harassment. We don't know yet, until at least the legislation is fully I should say that the Employment Rights Act is what we call an enabling act. So it introduces a number of provisions, and it's going to be through regulations, statutory guidance, that we get the absolute detail about what the law is and what needs to be done. So we are still waiting for that to some degree with what will constitute all reasonable steps. But what I would say is that it's clearly wider. It will probably be that, unless, well, effectively, if there is any relatively clear, relatively obvious step that you could have taken as an employer to prevent or at least minimize the risk of sexual harassment, and you fail to take that step, then I think certainly under an all reasonable steps approach, you are going to be found liable and failing for not having done an action you could have potentially taken. Case law will no doubt help define it as well, so it will be a case of watch going forward, but it's to be aware when this legislation comes in and we have all reasonable steps, the duty is obviously all the greater for you to observe and think about. Okay, on the next slide. So again, under the Act, employers will also be liable for harassment of any kind of their employees by a third party. For example, customers, suppliers, contractors, unless they take all reasonable steps to prevent that harassment from occurring. The government suggested that employers won't be penalised for failing to take unworkable or impractical steps, and employers only need to do what is reasonable depending on their specific circumstances. Again, we're going to have to wait for more guidance to see what this means, but it's a little bit unclear. It remains a significant concern for many employers, particularly, I would say, those involved in sectors with regular interactions with third parties, for example, health and social care and hospitality, about exactly what you must do and what steps you must take to try and minimise or eliminate sexual harassment from third parties. It will very much be a case of watch this space, try and look for as much information as possible about what you must do, particularly if you're in those sectors, particularly if you have regular interaction with the public, with contractors, with others outside the workforce itself, the employed workforce. We're expecting this duty to take all reasonable steps to come into force in October 2026. The government are said to be keen to stick to their roadmap. So this was a roadmap they produced for all changes that were arising under the Employment Rights Act. There were different dates as to when different changes to employment law should come in. Sexual harassment is being earmarked for October 2026. So I fully expect the law will change at that time. The all reasonable steps will come in. So it's not too far away, 8 months away, and we will have this law. So again, I would recommend keep your eyes open, look for changes, look for guidance as it's introduced, look to see what needs to be done to comply with that all reasonable steps action. Okay, next slide, please. Whistleblowing protection. So individuals raising complaints of sexual harassment will have greater protection. Specifically, complaints of sexual harassment will be a qualifying disclosure under whistleblowing legislation. And that's going to be actually effective from April this year, so not very far away at all. Personally, I think if somebody raised a complaint of sexual harassment, I would have personally said that it's probably already protected by whistleblowing legislation, to be truthful, but the Act makes it abundantly clear that it will be from April. So again, if somebody voices concerns, voices that sexual harassment is taking place, not necessarily to them as a whistleblowing complaint, it might be just more general, but they should have the protection afforded to somebody voicing concerns of that nature. Okay, next slide, please. Confidentiality clauses. So contractual provisions within a relevant agreement which seek to prevent workers from making allegations or disclosures in relation to work-related harassment or discrimination will be void. We don't know the date for this change. Hopefully, most of you or all of you that listen into this webinar won't have a confidentiality clause that would be used to suppress somebody raising concerns about work-related harassment. I know you may have in settlement agreements, if you ever use them, a clause for genuine confidentiality, but you'd hopefully introduce an exception to say whistleblowing complaints, other complaints can still be voiced. If you don't, I'd recommend making it a practice that you do amend a clause to allow for such disclosures, because whilst we don't know the exact date, it will soon become void if you attempt to suppress that within a confidentiality agreement. And then one more slide from me is just a reminder that the time limit for bringing an employment tribunal claim is also soon to be expected to increase from 3 to 6 months. Again, I believe this is to be done, I think this is a January 2027 change. I think it comes in at the same time that we are expecting the change for only 6 months employment to be able to bring a claim for unfair dismissal. But it's worthwhile thinking, because as things would stand at present, if you wish to bring a claim for sexual harassment, sex discrimination, you would need to do that within 3 months of the final act of harassment or discrimination that you were relying upon. But soon that will change and be extended out, so employees will have 6 months in which to be able to present a claim. And on that note, I will hand you back to Rebecca.
Thanks, Mark. So we've just heard from Mark about the changes that are on the horizon under the Employment Rights Act, and I'm now going to take you through a number of slides over what you can do whilst we await the changes coming into force. So as we've heard, sexual harassment can happen in any organisation, and it's really important that an employer must not assume that it will not happen in their organisation. The EEHRC considers that it's very important that every employer carries out a risk assessment to assess the risk of sexual harassment and victimisation in its workplace. And the EHRC goes as far as to state that an employer is unlikely to be able to comply with the preventative duty unless it carries out a risk assessment. And you can find that at paragraph 3.31 of the EHRC's technical guidance. So this is going to require that employers anticipate scenarios where their staff may be at risk of sexual harassment in the course of their employment and take action to prevent it taking place. In your risk assessment, you're going to want to consider any factors specific to your sector, the type of work, the ways of working, and the different roles in your organisation. And the EHRC suggests that employers consider appointing a designated lead to take responsibility for implementation of their risk assessment action plans and compliance with the preventative duty. And you can find that suggestion at paragraph 4.15 of the EHRC technical guidance. We said at the start how we would be referring to the technical guidance throughout today's webinar. And I hope you can see from the number of references that we have made to it just how important this document is to be familiar with as an employer, because I suspect that it is going to be heavily relied upon in case law moving forward. So employers should assess where in the organisation sexual harassment would be more likely to occur and the particular risk factors relevant to its business. So what we're saying, in other words, is it's not just enough to do a standard risk assessment. That risk assessment is going to need to be tailored towards your organisation, your business, and the particular risk factors that arise. And the EHRC has identified some areas that may increase the risk to help employers with this. And we've put a few examples up on this slide there. So power imbalances, so particularly gender power imbalances, where most junior staff are perhaps women and most senior managers are men. And there is further guidance on this, which you can take a look at on the technical guidance yourself. Job insecurity, so for example, those members of staff who are perhaps on 0 hours contracts, who are agency staff or who are contractors, if you as an employer use any of those, then they could be potentially higher risk factors for sexual harassment taking place. The HRC also gives the example of lone, isolated and night working members of staff, or those that are working alone with a third party. So give consideration to whether you have any members of staff that are doing those in your organisation. Out of hours working and the presence of alcohol are also examples referred to by the EHRC, and those individuals in your organisation that have customer-facing duties. Continuing with potential higher risk factors, and this is not an exhaustive list, I should say, but it's just an extract of a few of the examples on the EHRC. There are a number, so do take a look at them. Particular events that raise tensions locally or nationally if your workforce is involved in any things of that nature. A lack of diversity in the workforce, especially at senior level. Workers who are on secondment. Workers who travel to different work locations, working from home. And there's a specific dedication, a specific page in the EHRC guidance dedicated to remote working, which is really interesting and worth reading, especially in the current climate where a lot of workers remain remote working from home, for example. Consider also workers who may have to attend events outside of their usual working environment. So this could be training, conferences, or work-related social events. And the HRC say that any expectation that staff attend social events or conferences outside of the workplace or stay away from home overnight is an increased risk factor, particularly if alcohol is also being consumed. Socialising outside of work and social media contact between workers are also examples of higher risk factors. So in addition to a risk assessment, the EHRC have also suggested that employers may wish to consider implementing an anti-harassment policy. Now, we already know that you must follow a full and fair procedure for handling complaints of any nature in line with ACAS's Code of Practice on Disciplinary and Grievance Procedures. And you could do that through either your existing grievance procedure or a specific procedure. So in this instance, a specific procedure for handling sexual harassment complaints. And that could be part of a sexual harassment policy. So the EHRC is suggesting that you should indeed have one of those policies in place, an effective anti-harassment policy. And it goes further to suggest that this policy needs to be regularly reviewed and brought to the attention of all staff. The EHRC suggests that the policy should confirm who it covers, make very clear that sexual harassment is unlawful in the workplace and will not be tolerated, state that sexual harassment or victimisation may lead to disciplinary action, and that is up to and including dismissal. It should also state that aggravating factors such as abuse of power over a more junior employee will be taken into account in deciding what disciplinary action to take. The EHRC also suggests that it should set out a range of approaches for dealing with harassment, from informal solutions to your more formal disciplinary processes. And it should set out clear definitions of sexual harassment, less favourable treatment for rejecting or submitting to sexual harassment, and victimisation, with examples relevant to the employer's working environment that reflect the diverse range of individuals that harassment may affect. So your policy is going to need to not only define sexual harassment for your employees, it's also going to need to give them examples, and those examples must be tailored to your workforce. Whilst on the subject of policies, it's just important to note that if you're going to be implementing a new anti-harassment policy, you need to make sure that your other policies are going to match up. So you'll probably have in place a social media policy or perhaps a dress code policy. And whilst implementing your new anti-harassment policy, it's important not to forget those other policies and to check whether they align. If we take the social media policy as an example, that policy should make it clear that online sexual harassment will not be tolerated, and that includes perhaps on personal devices that your workers may own. It's also going to be necessary to make these things clear to everyone who works for you. So it's not enough to simply put in place a new policy or amend existing policies. You also need to make sure that everyone that works for you is aware of them. So you need to make them aware of any anti-harassment policies or sexual harassment policies that you introduce or update. You need to make them aware of the consequences of breaching that policy, and you need to make them aware of how they can report sexual harassment. And the EHRC says that employers should consider publishing their policies on an easily accessible part of their external facing website. So this would allow staff who cannot access their employer's internal systems, such as those on sick leave or contract workers, to obtain a copy of the policies. I mean, it also demonstrates the employer's commitment to transparency and tackling the issue. So I think it's fairly commonplace, obviously, for employers to publish their policies internally amongst their employees. But you can see from the EHRC's technical guidance that their suggestion goes further than that to suggest that it should also be public facing, i.e. on an external facing website. Moving on to training. You must consider providing training to all staff and not just your managers. So what do we mean by training? This means telling everybody in your workforce that sexual harassment is not acceptable. And you could do this, for example, as part of their induction. You could and you should train everyone who works for you on recognising and understanding sexual harassment. Training managers specifically on how to assess and manage risks of sexual harassment, and training someone to advise people who are considering making a sexual harassment complaint. So, for example, someone in HR, a manager, or another member of staff who are potentially going to be dealing with those complaints. And the EHRC technical guidance recommends, that it's put in place for all staff, as I've said on the slide there, not just the managers. So supervisors and managers may need some additional guidance on what to do, as we've just mentioned, in relation to responding to a complaint of harassment. But all staff are going to need to be trained on sexual harassment. So it's good practice, as I suggested, to maybe use it as part of your workers' induction procedures. That's an effective way of ensuring that all new staff to your organisation are clear about the behaviours expected in the workplace and how to report it. And you could provide a copy of your policy as part of your workers' induction pack. The EHRC technical guidance says that the training should be tailored, and it should be tailored towards the nature of the employer, the target audience. So we've spoken about seniority and job roles of the audience, and the best method to deliver the training to those individuals, the characteristics of those most likely to perpetrate sexual harassment in that workplace, and the employer's policy to maximise its impact. So, for example, in industries where third-party harassment from customers is more likely, training should be provided on how to address such issues. And this will vary from employer to employer. In a call centre, for example, a manager may require guidance on what to do in the event of a worker receiving an abusive phone call, whereas in a pub hospitality environment, the manager may need guidance on what to do in the event of physical or verbal abuse. So it's really important to think about your own workplace and to tailor the training to those members of staff and what they are going to be coming into contact with potentially. The EHRC also suggests that there should be regular audit of your workplace culture through surveys and staff engagement. And this tool will be really important for you as an employer when you're assessing the impact of the steps you're taking, to be able to determine whether those steps are effective. And I think employers are going to need to be seen to be prepared to adapt their approach when necessary. So if you audit and find that, the steps you've taken to date haven't been effective, what can you do to change those steps to perhaps try and improve the effectiveness of your actions? Risk assessments are going to need to be reviewed regularly and mitigating action taken if there's any risk or any new or additional risk identified. And the EHRC actually puts in their technical guidance an 8-step approach that employers can take to evaluate the effectiveness of your steps taken. And just to give you a few examples of those, the EHRC talks about monitoring informal and formal complaints and your data of those complaints to see if there's any trends or particular issues and appropriate actions that should be taken. They also suggest conducting anonymous staff surveys to obtain information on experiences of sexual harassment, including whether they have witnessed or been subject to sexual harassment, whether they would report it, and what further steps they think the employer should take. The EHRC also suggests comparing reported complaints with survey feedback to ensure an accurate reflection of the levels of sexual harassment in the workplace and taking appropriate actions. And they suggest holding lessons learned sessions after any complaints of sexual harassment are resolved. Employers should also monitor the treatment of discrimination and harassment complaints within the organisation to ensure that they are properly investigated and resolved, that those who report are not victimised, and that settlement agreements containing confidentiality clauses are used in an appropriate way. So Mark has already spoken about the need to ensure that you're not seeking to silence someone who is perhaps raising allegations of sexual harassment. It also suggests the technical guidance that preventative steps are taken to ensure that future sexual harassment in similar circumstances does not take place. So lots of things to think about. And as I say, a really useful 8-step guide in the technical guidance, which I would suggest you have a look at when you have some time. We've spoken about the importance of addressing third-party risks over some of the other slides, but just to re-emphasize this point, employers might wish to review the steps they've taken to date in respect to third-party harassment to determine whether additional steps are required. For example, if you've not already done so, employers may want to consider inserting wording into supplier contracts, asking for details of third parties' sexual harassment risk assessments and preventative measures, or introducing code words for staff to use if they feel vulnerable in a situation with third parties. Another thing an employer could think about is perhaps adding appropriate signage in venues where third parties may be present. Employers should also equally take reasonable steps to ensure that their employees do not harass any third parties with whom they come into contact during the course of their employment. A harassment claim could be brought against the employer in its capacity as a service provider under the Equality Act, and anything done by their employee in the course of their employment is treated as having been done by the employer, regardless of whether the employer knew or approved of the act. And the employee themselves would also be liable. So important to look at third parties from both sides. Just a quick note on volunteers and interns, some of which are not protected by the Equality Act 2010. The EHRC considers that although volunteers are not protected under the work provisions of the Equality Act, they may be protected under the service provisions of the Act if the organisation providing the volunteering opportunity is providing a service to the volunteer. It is noted in the technical guidance that this has not yet been tested in the courts, so we'll have to see if that happens in due course, but for now, just something to be mindful of. Mark has spoken about the commencement of the various provisions of the Act. Relatively few of the provisions of the ERA came into force immediately, and most of those changes, as Mark said, require commencement regulations to bring them into force and further substantive regulations before they can come into effect. But I think it is still fair to say that the timescales that we have been given and are aware of are ambitious. So the more you can start planning now and taking action now as an employer, hopefully the more ready you're going to be when those regulations come into effect. And that's it for our webinar this morning. If anyone has any questions, please do share those with us. And if there's no questions, I'd just like to take the opportunity to thank everybody for coming along to this morning's webinar. Thank you, Mark, for joining us.
Yes, thank you, everyone.
Thank you. Good morning, everybody.
Good morning.